you're going to have side conversations, if you step outside the room, although it may not pick up the conversations clearly, the recorder will get the background noise and it will make us harder to hear anybody that is speaking on behalf of the role. If you would like to speak and have not signed up, please do so over there. I'll repeat that again in a minute when I read some opening statements. And when you are called to speak, if you'll come up to the table here, that way we make sure that our recorder picks you up good and clear and we get everything, okay? So we'll start with an opening statement. Let me get this turned on. I'm Jennifer Gurr, Acting Commissioner for the Colorado Department of Agriculture. This hearing commences at 10:03 a.m. on Friday, January 23rd, 2015. This rulemaking hearing is being conducted in accordance with the State Administrative Procedure Act, Sections 24-4-101 through 108 of the Colorado Revised Statutes, consistent with the notice of rulemaking that was published in the Colorado Register on the 25th day of December 2014. Copies of the proposed rule are available on the table. This hearing is concerning proposed revisions to rules pertaining to the administration and enforcement of the Industrial Hemp Regulatory Program Act at 8 CCR 1203-23. The purpose of this rulemaking is to add and amend definitions and language. Amendments are proposed throughout the rule that will change registration, reporting, inspection, waiver, and violation, disciplinary sanction, and civil penalty requirements. Amendments will also incorporate changes as a result of the department's regulatory efficiency review process. This is the only hearing scheduled for this rule. Its purpose is to allow all interested parties the opportunity to present data, views, and arguments pertaining to the proposed rules. Your presentation may be oral or written or both. Oral presentations will be limited to 5 minutes each. Please confine your comments to the issues presented by the proposed rules. While we realize there are a number of concerns with seed availability and processing, these items are not covered by the scope of this rulemaking. In order to ensure that everyone has time to speak, I may interrupt you if your comments extend to matters not related to the proposed rules. At the conclusion of your presentation, I may ask questions of you concerning your presentation or other relevant issues. Any person who speaks at this hearing must record his or her name and address on the sign-in sheet located on the table. If you are representing an organization, you must identify the name of the organization as well. If you intend to speak but have not signed in, please do so now. If you have written comments or other information that you would like to submit for consideration, please give those to me at the time of your oral presentation or deliver them to me no later than close of business today. The Commissioner will consider all oral comments and written information submitted. Once the rules are finalized, they will be presented to the Colorado Agricultural Commission for discussion and approval at a meeting on Wednesday, February 11th, 2015 at these offices in Broomfield. The public is welcome to attend that meeting. However, the Ag Commission will not take additional public comment on the rule. If approved by the Commission, the final rules will be adopted by the Commissioner and published in the Colorado Code of Regulations. They will become effective on March 30th, 2015. So we'll start with having Dwayne present the rule.
Well, again, thanks everybody for coming. Dwayne Sinning, I handle the hemp program and I'm the Assistant Director of Plant Industries here. I'll be covering the statement of purpose and factual basis for the rules today that begin on page 10 of the copies that are on the table over there. But for the sake of time today, I'm not going to read all the rules. I'm going to go through some of the key rules that have been proposed, summarize and try to focus on some of those. So with that in mind, we'll kind of get started on some of the rule changes and some of the verbiage that you'll see. First, one of the questions we've been asked a lot is why do we use the word cannabis and not industrial hemp through the whole rule? Just to clarify that, The reason we've used cannabis is because we may not know after the registration process what that plant is, and so we've defined it as cannabis. It is no way intent, the way it has been construed, that we want to take on marijuana or anything else. It is a case where it is undetermined whether it is marijuana or industrial hemp. And until it's determined, we've used the term cannabis. So that's purely just for clarification purposes on that. Some of the rule changes, again, I'm not going to touch on all of them. You'll find them in the back of the copy over there. But I will touch on some of the key ones. So first, clarifying commercial versus R&D and registration. Commercial really is the growth of industrial hemp by any person, legal entity, or other than an institution of higher education or under a pilot program administered by the department for purposes of agricultural academic research in the development of growing industrial hemp. R&D, the research and development, means the growth of industrial hemp either by an institution of higher education or under a pilot program administered by the department for the purposes of academic or agricultural research in the development of industrial hemp. The reason those two rules have been changed is, one, those rules or those definitions were adopted prior to the Farm Bill language. We are now trying to become Farm Bill compliant with R&D. That allows our universities the opportunity to have some Farm Bill compliant and to work on a pilot program accordingly. It does not in any way restrict your ability to do R&D under a commercial application. And I like to use an analogy. Ford Motor Company in 1960 had a bunch of drawings in the back room. In 1962, they had a few concept cars. In 1964, they launched the Ford Mustang. And every year since, they've continued to do research on that car. So the same thing is true in hemp. The same thing would be true in almost any other industry. You're still allowed to do research. You're just doing it under a commercial permit. So it's basically a research division under a commercial permit. The other part to that rule, we had a number of research and development registrants that came to us during the year and wanted to sell their research and development material. Well, under an R&D permit, that's really intended for R&D, for to go to the program and for R&D. It's not to blend the two and have them both. So the new definition being done, R&D under a commercial application, would allow those registrants to sell that. So it basically untied their hands and gave them the ability, will give them the ability to be able to sell the byproducts of their research and development. Okay? We also are clarifying the difference between registrant and registration. We get a lot of calls from, whether it's newspapers, the governor's office, a number of places. How many registrations do you have? Or how many registrants do you have? And so we have, we've adopted language that a registrant means an individual or an entity who holds a valid registration to grow industrial hemp under the rules. And a registration means the authorization by the commissioner for an individual or entity, that registrant, to grow an industrial hemp on a designated land area. So it helps to clarify those two issues. Let's see. Terms of payment, we've adopted something there that just basically states one of the issues we've had has been some registrants have used the lack of terminology in how long they can not pay a bill. I'm sure most of you would find it real interesting if you didn't pay your bills for 6 months, how long the electricity would come on, or whether you'd have to pay that before you got your electricity turned back on. So all this really does is say that there's a 30-day period from the date of the invoice to payment. It just really clarifies that. Part of the reason for that is as we've had to go back to remind registrants that there's an outstanding bill, that adds cost to the program, the administration costs, and that just has to be passed along to everyone. So it's to help control costs as well. Registration transfers. The language now says registrations cannot be assigned or transferred to other businesses, individuals, or entities. The purpose of that is because it's to prohibit the transfer of registration to someone that may not be otherwise qualified. and therefore, or to avoid penalties that a person that has the ability to get a registration could pass it along to somebody else. So this just protects everyone to know that all the registrants there have the intent to be doing and the ability to register and carry that registration on. So if you've registered, you've got the permit and it's for you, not for somebody else. Define what plant material can be included in a registered land area. That rule reads, no registered land area may contain cannabis plants or parts thereof that the registrant knows or has reason to know are of a variety that will produce a plant that when tested will produce more than 0.3% THC on a dry weight basis. No registrant shall use such material for purposes associated with the cultivation of industrial hemp. Amendment 64 stated that marijuana and industrial hemp are to be regulated separately from marijuana, that industrial hemp is. And so we've taken the position that the only way we can solve some of the issues we saw this last year where they were used together, knowingly used together, which we felt was an issue for a number of registrants that were trying to purely stay in industrial hemp. It's somewhat worrisome to law enforcement. Some of our other registrants are concerned where the DA may look at, how they may look at it, that we've decided that those really need to be separated, just the way Amendment 64 intended. And so we felt it was necessary for the plant material that is included in a registration that the registrant should know that it is industrial hemp. Doesn't mean that we won't still have material that goes over, but you shouldn't knowingly be including marijuana in industrial hemp registration. To kind of continue on with that, we have put some setbacks from marijuana in an industrial hemp registration. And that reads, in order to minimize the possibility of cross-pollination with marijuana plants, no registrant shall grow any industrial hemp plants within 1 mile of any other cannabis plants that are not included in industrial hemp registration that are growing outdoors, or within 1/4 mile of a cannabis plant that are not included in industrial hemp registration and are growing out indoors unless specifically authorized by the commissioner. This provision in Rule 2.6 is really needed to prevent the pollination of marijuana plants from being crossed, as I said, with industrial hemp knowingly by a registrant. But the rule does provide for a registrant that has made containment provisions, has protected his marijuana inside that set aside. You can come to the commissioner's office and discuss those, and we can look at those on an individual basis. Definition of a registration, or define what can be in a registration. Each non-contiguous land area on which industrial hemp is grown shall require a separate registration. Any addition to a registered land area shall also require a separate registration. That's Rule 2.7. And that really is set to define what is a single registration. And that is that it's the land area that you've got, and it's not moving from one land area to another land area. We had a number of cases this year where we had somebody register a land area, and then they move to another land area when they harvest, and then they move it to this, and then they move it to an indoor, and they move it to an outdoor. And what that does is add a tremendous amount of administrative costs, which again adds to the cost of the program. And then sometimes it was literally a shell game. We were chasing around trying to figure out where the plants were that we were trying to sample. So this defines what the land area is, where you've registered. If you are looking at a land area and you don't know, well, I want to do an acre, and you've got a 10-acre plot, which might go larger. If you register that whole land area, you can still plant in that land area. You don't have to do in each one. You'd have a different planting report. but it does define what that land area is. And if you go outside of that 10 area, you want to go to another place, a completely different place, you'd have another registration. So this we just feel helps come up with an equitable fee structure for those people that are doing, they aren't paying for somebody that's moving registrations all over the place. Set fees for the program. Annual registration fee for a commercial production or R&D of industrial hemp shall be $500 plus $5 an acre outdoors, or 33 cents per square foot indoors. This really, that is, for those looking, that's in Rule 2.9 and 2.10 really. And that's really to comply with the self-funding mandate set forth in Section 35-61-1062 of CRS. Current rules, right now, the way we have structured the fee structure, has generated less than 20% of the total funds that it takes to administer this program. So our options are limited. We have no ability to raise fees based on use. Our fees can purely be done on a registration, a land area, or the acreage. It can't be done on use. So we've had some people say, well, why can't you do one project that has greater value than another project? We don't have the authority to do that. The only thing we can do is based on the registration fee and the land area. Had we left the registration fee at the same fee it was and raised it on land area, that would have meant the land area would have been over $55 an acre to cover that cost. On the surface, initially, when you're doing a small research project, that may sound good, but what it does is kill your marketplace. You've got no way to sell it to a farmer or anybody that's doing a large scale afterwards. So this we felt was the most equitable way to finance the program and allow the entire program to grow, not just one segment of it. Define amendments to the registration. Amendments to an existing registration are limited to changes within the original land area registered, including variety changes, locations of varieties, and actual acreage or square feet of each variety planted. Again, this is necessary for us to control where those registrations and how we manage them and how we know where they are. Again, if you have a 100-acre site, you plan on planting 10 acres, don't know where you're at, you could still register all 100 acres, plant 10, and plant 5 more later, and it's still in that registration. You have a planting report you'd be turning in, but you don't have to do 10 acres and then decide to do 2 more. If you're uncertain, I would encourage you to take that larger look at what your potential is. Currently, as I mentioned, registrants have used this as a way to establish multiple growing sites and move them around, and it just really adds a lot of cost to the program that we don't want to pass on to everyone. Require current contact information. Again, this was one that we struggled with. Any changes to contact information must be provided within 10 days of the change. We had a number of cases where we spent more than 30 days trying to find people. When we sent out a registration notice, it came back. We'd make a phone call. The phone call was disconnected. We had no way to get a hold of people. So it's just really to try to make sure that our registrants and us stay in contact and we know how to get a hold of people. Establish a planting report. Within 10 days after planting, each registrant shall submit a report with the commissioner that includes a list or description of all varieties planted within a registered land area and the location and actual acreage or square feet of each variety planted within a registered land area. This really is important for a number of reasons. As we look at what information we generated this past year, we know how many acres was registered, but without a planting report, we can't tell how many acres in this state was even grown. That complicates a little further is we spent a lot of time this year. We sent out harvest record reports that everyone that planted is required, and we got a number of those back. We got a number that said, well, I didn't turn something in because I didn't plant. But that took time and energy and cost to the program to find out. So We also understand that when you register, you may not know what variety you have. You may not know what that THC is. You may not know if you're even going to get seed. So this really allows you to come in and register with good intent of what you're going to plant. But after you've planted, you should know what that is. You should know whether if you have a variety or where it came from. And so it really ties up the registration process of what was there, as well as allows us to know who planted and how much is planted. Inspections. All registrations are subject to sampling to verify the THC concentration of the cannabis planted in the registered land area does not exceed 0.3% THC on a dry weight basis. The commissioner shall select up to 100% of the registrants to be inspected. The commissioner shall send notification to each registrant of their selection. The notification shall inform the registrant of the scope and process by which the inspection will be conducted and require the registrant to contact the department within 10 days to set the date and time for the inspection to occur. Failure to contact the department will result, the department as required will result in the initiation of disciplinary proceedings pursuant to Part 6 of the rules against the registration. That was a long one. A number of points there. First of all, sampling, the old rules stated that it was up to 33%. Those were at a time where we had a May 1 only deadline. So it was easy to evaluate how many registrants you were working with, and you can draw a line at 33%. Since that is a moving target now, it's impossible to come up with a 33% number. So while our intent is not to do 100% sampling, we don't have literally the staff or the lab isn't going to take the ability really to push it through our whole process. It just means that we don't have to worry about a line in the sand that is a moving target for us to deal with. So that really helps accommodate the rule change we made in July that allows everyone to register on a year-round basis. The other part that is important is that it eliminates the 2 years prior registration allows us to do it on an ongoing basis, and that's important. We've had a number of law enforcement have said, boy, what does that mean after 2 years? You can't test them, and the truth would be yes, we couldn't have tested, and so therefore that meant someone that's been tested 2 years in a row now has an open ticket to do an illegal marijuana grow. So this really takes us into the ability to make sure that we're protecting our registrants, that we don't have someone abusing the system. And the change from 30 days to 10 days after notification is important. It really follows along with that. How long do you have to communicate to us any change in address? This just coincides with that, and it allows us to determine faster how we can get out to the field before that 30 days is over, and we're out there too close to the end and we can't get data back, or we can't touch base. So, and the last one I'll touch on will be sampling. Individual or composite samples of each variety of cannabis may be sampled from the registered land area at the department's discretion. And the reason this is really important is we have a number of breeding projects out there, and currently the language said that we would come out and take a composite sample. If you have a breeding program and you're taking a composite sample off everything, you have done significant damage to a breeding program. So our intent here is to make sure that we're able to come in, sample, look at records and those things, and then maybe take individual plants as a sample process to confirm the records that are there, but it won't require us to destroy a breeding program in order to comply with the rules. So with that, those are the ones I'm going to touch on. As I mentioned before, there are more what I would call less key, less significant rules that we didn't touch on, but you will find those all in the proposed copy of the rules.
Thank you. Before we move on on to the public testimony. I wanted to address the written testimony that we've received, and most of these came in through email. I believe all of them came in through email. So just real quickly, we received written comment from Thomas Ivory regarding the separate registration required for additional registered land and the increase of registration fees. Darwin Millard regarding the definition of commercial and questions related to the Farm Bill and federal law. We received a number of comments regarding the fees being lowered for nonprofits. Those came from AJ or Xander Hobbs, Josie Castaldo, Stacy Stein, Moses, R. Scott Mills, Jackie Chenoweth, Sue Gray, Jimmy Dula, Kim Doyle Willie, Jeannie Perry, Summer Star Haskey, John Colson, Diana Alcantara, and Lisa DiNardo. We also received a letter that was submitted by Karen Kirschner. The letter addressed